Mr. Bott.
Thank you, my lord. I have about half an hour left of submissions, I think, at the most. I was just addressing our final subject, which is our appeal in relation to haulage. I took the court to the base case financial model at core bundle page 1045, where we saw the total value of variable haulage. And as I indicated before, the short adjournment, that was all the information we had about that sum. That it was clearly more than was necessary for contract weights, but we didn't know how it had been calculated. I was then taking the court to the contractor's O&M model, which we have at page 479 of the supplementary bundle, and that showed the calculation of a per rate tariff. And that's material that was disclosed to us relative in early 24 from memory, not long before the trial started. And then I was about to take the court, which I now do, to a statement of the author of that document, a gentleman called Mr. Dixon, who gave evidence at the trial. His evidence was relatively uncontroversial. He just explained how he had prepared the so-called O&M model. The statement is in the supplementary bundle at tab 17, starting at page 529. And the relevant section starts at 556. So when he refers to the O&M model, there are various versions of it, but it's the cost of operating and maintaining the facilities, but includes haulage, which is obviously an activity taking place outside the facilities on public roads. At paragraph 7.1, it says the O&M model calculates the haulage cost of transporting waste from the transfer station, and clearly he means there High Heavens and Amersham rather than the other transfer stations that are referred to in this case, to the plant. So the contractor's case is this is a calculation of movement of contract waste and third-party waste within the facilities. And the short point we're making is, yes, but it would also be the same cost or equivalent cost from other transfer stations if you choose to use Kingsway rather than High Heavens, for example. And then at paragraph 7.2 explains, as for haulage to the plant, when he says the plant obviously means the EFW plant at Greatmoor. As for haulage to the plant from transfer stations, described as TLS O&M variable haulage, the court will recall that's how it's described in the base case document at page 1045. Haulage to the plant is the cost of getting the waste from the transfer station to the plant. It does not cover the cost of getting waste to the transfer stations or indeed directly to the plant. These costs were not modelled and could not have been envisaged because we did not know in 2010 when the rebid was first submitted, or in April 2013 when the PA was signed, where the third-party waste would come from or on what terms we would acquire it. For example, whether we would be responsible for transporting the waste to the facilities or whether it would be direct delivered. Now, pausing there, with all respect to Mr. Dixon, who was extremely helpful witness, this passage does have a slight air of legal argument here. He's saying, well, we did include this, but we couldn't include the other because we didn't know what it was. Well, they didn't know any of it. There was going to be this requirement for a huge quantity of third-party waste, however it was going to be achieved, and that was going to need to get to Greatmoor. And hit the argument that he is making at 7.2, well, we didn't know where this third-party waste was coming from. Well, on that basis, why is there any provision for haulage? And we say what we understood we were getting, or what a reasonable party to the contract would assume, is FCC is making appropriate provision for moving waste to Greatmoor in sufficient quantities that it will be able to meet this immense commitment of guaranteed third-party income from third-party waste. It is correct that we do not know how they're going to do it, and they don't necessarily know exactly how they're going to do it, but they must have some idea to enter into this eye-watering commitment. 600 million in today's prices is something like 924 million just on the basis of Bank of England inflation. So, and as I've said before, the anomaly that arises is if they don't use that haulage from high heavens, they're still getting the income that Mr. Dixon had calculated. So we say, well, surely the most obvious solution to that apparent anomaly is when they come to claim haulage costs, one needs to take into account, in other words, the haulage of third-party waste, one needs to take into account, well, they were always going to need to do that. And that, therefore, is cost that's in the base case for the purpose of Proviso B, albeit a different route, and or perhaps more obviously, Proviso C, it's the handling of third-party waste, which is expressly excluded. Back to Mr. Dixon's witness statement. He just explains the maths of it, and if you look at paragraph 7.6, he explains that in these 2010 prices, got the first year of haulage costs of 1.9 million. Of course, that's including contract waste, so it's not all third-party waste. But nonetheless, a significant proportion of that is third-party waste. Also of relevance is, it explains the relationship. So paragraph 7.10, he's referring to the rates, and that rate of 9.77 is not, in fact, the same as we have in the O&M model, because he's obviously appears to have been using a different version of the O&M model. But I took the court before the short adjournment to the rates at page 479 of the supplementary bundle. What we can also see at paragraph 7.9 is Mr. Dixon has applied a margin of 7.5%. So he's calculated the cost of hauling a ton of waste from a waste transfer station to Great Wall, and then he's applied margin to that, profit and overhead. All the O&M contractors' costs were subject to an uplift. And then on the next page, 30, he's explaining the calculation of the rates times by the quantities from High Heavens Waste Transfer Station in order to generate the overall value. And that corresponds to the spreadsheet at page 480 in the supplementary bundle, what we see at the top of 558. At 7.12, he explains, cell M417 contains a value of 52,109 tonnes. This is the volume of waste delivered to the High Heavens transfer station by Buckinghamshire Council. So that's contract waste. And at 7.13, cell M923 contains a value of 78,000 tonnes of C&I waste. This value is a hard-coded number and corresponds to the figure which appears in figure 4 of method statement 9 transport claim. And the court will recall that my learned friend took the court to the method statement, which had the map showing where the waste was going to come, where it was proposed that the waste would come from. He says at 7.14, I confirm the model did not account for getting that third-party waste to the transfer stations for the reasons I've discussed. I repeat my earlier comment. And then 7.16, the distance being used to calculate haulage costs is the round-trip distance from the transfer station to the plant. And he's used 90 miles for High Heavens, and we see that calculation at page 479, which is what he's explaining. So that's the maths of it. Key points to note, it does indeed include the movement of third-party waste to Great Moor in significant quantities, as we can see from these calculations. It includes a calculation of costs together with an uplift for profit and overhead. It is, in a sense, speculative for the reason that Mr. Dixon keeps saying that we don't know how exactly this is going to go. nonetheless, it's very significant sums of money. And if, as my learned friend says, well, they don't need to do anything, they can just pocket that money and leave others to bring the waste. If that is correct, well, the converse must also be true, that if those costs in fact turns out to be more difficult than the contractually thought, why on earth would the corollary not apply? So, as indicated before, the shortage generally rely on both provisos B and C, but specifically C, in terms of the construction of the words used. Proviso B refers to, if I could just give you 1 moment.
You're moving on from C. Can I just ask, this is myself, what costs would not be excluded by proviso C? If you're right.
Well, as the learned judge pointed out, I mean, third-party income is dealing with a whole range of activities. We're focused exclusively on third-party waste,
yep,
third-party income. But I mean, we've also had litigation about the third-party income from metals, whether that was a recyclate or not. But there are other ways in which third-party income could be generated, to which proviso C would be irrelevant.
Well, in relation to the third-party waste going through Great Moor, etc., I just wondering what costs would not be excluded from that on your basis?
Well, my lord, with respect, my responses with proviso C is concerned to exclude the costs of dealing with third-party waste. I accept. That still leaves costs that are unrelated to third-party waste. But in terms of, if the question is, put this way, as we see it, FCC B is charged with bringing this huge quantity of waste to Great Moor and processing it. They've committed to that in the sense that they have guaranteed that that's what they're going to be able to generate, and they need that both for electricity and waste. In our minds, it would be quite wrong if they can then deduct the cost of essentially discharging that function, which if they were able to, but for proviso C, they would be.
Yes, I mean, you may well right. So effectively, it's all costs in connection with that.
I think the answer, my lord, is that the costs, if we look at the costs that they seek to recover, they have their operational costs, which is haulage and potentially manpower or bits of manpower. Mm-hmm. And we would say, well, yes, obviously those costs are excluded because your quantities of waste are essentially fixed by the capacity of the plant, and the distance that they're going is fixed by what's economically viable. We would be astonished if they could recover those costs in deduction of TPR. There are other costs that they claim that we say fail for other reasons, but that would not fail for proviso C. For example, insurance of buildings fails for proviso A, or it's not a direct cost. It is not on the face of it falling foul of proviso C.
But then on the other hand, is there anything left to save at the C stage? I think I've expressed that badly. I mean, you say haulage and manpower are knocked out. You say all the other things are knocked out too on one basis or another. So really, there isn't anything left.
Well, I think each provision must be read and given its natural and ordinary meaning. If the combined effect of the three provisions, three provisos, is that not much is going to be there, or nothing is going to be there, I suggest that's not a sound basis for then revisiting the individual proviso.
I wasn't suggesting otherwise. I'm just trying to get to the logic of the conclusion.
My Lord didn't mind me suggesting otherwise. Maybe I was misinterpreted it.
And I mean, just trying to think. By the time you get to C, you've knocked out costs that aren't directly incurred. You've knocked out costs that aren't specifically and solely related to income over and above the base case. You've knocked out costs that aren't over and above the costs envisaged in the base case. So one then thinks, well, why is C there?
My Lord,
sorry, go on.
Well, I argue that we'll see meets the situation where waste is brought to Greatmore, but instead of going via the defendant's case, the FCCB's cases, our haulage cost that is in the base case is for a different route. So it's like a sort of, heads we win, tails you lose type argument, which we consider deeply unattractive. They're saying that simply because it's come from Kingsway rather than High Heavens, almost exactly or very comparable route, and it's the same exercise. They say, well, we're allowed to deduct that whilst retaining the full benefit of the base case. Just to be clear, no third-party waste goes through High Heavens, as I'm sure we've made clear. And we say that, well, that on the face of it is a slightly surprising result and does require one to review the meaning of provisos B and C, and we rely on them in the alternative. One solution is to look at proviso B and say, well, they are getting haulage costs in the base case, albeit a different route, but that is for the purpose of proviso B. That is a cost that is envisaged in the base case, in that third-party waste haulage to Greatmore was envisaged, albeit in a different amount and different quantities and so on, because as discussed, that's the risk that the contractor took on. The alternative argument is proviso C is there to meet just this scenario. If the contractor has prepared a base case that is inadequate for what they then decide to do, because they decide to route the third-party waste, slightly differently, why then should they nonetheless get the benefit of the base case and deduct those costs?
I mean, the judge ultimately ties this to Greatmore, doesn't he? But leaving whether or not he's right about that.
Sorry, my Lord, can I interject before we get any further? He ties it to the facilities. So he says, yes, this is referring to waste that's arrived at the facilities, so it's between facilities, which was the contractor's case.
Sorry, but at any rate, it's obviously aiming to do something. So I suppose you say, well, it's saying, look, whatever else you can or can't deduct, we think you're already getting enough for handling and processing third-party waste, and so you can't have any more.
Specifically, you are the waste expert. You have costed it. You're doing this all the time. You've worked out what you need to do to cover your cost and generate a margin. Of course, there is a huge element of risk over a 35-year term. Could be changes in legislation, other plants growing up, and all the rest of it. But you, the contractor, have taken a punt as to what needs to be in here to cover this, to generate this income and run the plant. In the event that you make some relatively trivial change, it's not trivial in the sense that a lot more waste is brought to Greatmore than was shown in the transport plan. I can't remember, but very, very roughly, I think with those 3 third-party waste contracts, they must involve haulage of something like 150,000 or something tonnes, whereas in the transport plan, I think we just saw Mr. Dixon refers to 78,000 tonnes, and I think that's reduced when Amersham is lost. So there's quite a big difference. There's no two ways about that. But we said, well, yes, you're the waste experts. You're not showing us your calculation of how you've worked all this out. They don't want us to know what risks they take, what margin they make. So we say that makes sense, and it's a better result than the contractor simply getting the benefit of the third-party waste haulage that's not used, and not having to give any credit for that in any form. And my lord, just a couple of points before leaving haulage. I'm sure the court's appreciates our point that when the judge was going through provisos B and C, we tried to make the same argument. So proviso B is dealt with, it's core bundle tab 10, page 124. Starting at paragraph 220. At paragraph 223, his lordship, if I may say so, very fairly summarised what I was trying to argue. And then this passage, which I referred to earlier in the context of directly incurred costs at paragraph 224, where the judge said, well, the FCC points out that they have to have the waste transfer stations to accept contract waste, so they needed high heavens for that purpose, so they weren't allowed to close those. And then his lordship says there's no evidence that any significant cost would be saved at high heavens waste transfer station or Amersham, given that they would have to be kept open for contract waste, even if third-party waste was diverted elsewhere for handling. And we say that's wrong with respect, because there is a saving in haulage. They have this huge income for moving third-party waste from High Heavens to Greatmoor. If, as happened, they don't use High Heavens for that purpose, then they do reduce, if nothing else, their haulage costs. So that anomaly survives, and the learned judge did not identify or reference our main point, which was, yeah, but the haulage cost is saved. At paragraph 225, he says that this assumes FCC would have some commercial incentive to act in this way. I don't think, with respect, I don't think it's necessary to consider it in that way. The question that arises is, how, as a matter of construction of the provisos, should one treat the reference to handling third-party waste in the context of proviso C, or envisaged in the base case in proviso B, in circumstances where there is money in the base case for hauling third-party waste to Great North, but as it happens, FCC uses a different route. Are they allowed to rely on that relatively modest change to their proposals to receive the money twice as a group? And paragraph 2 through 6, when his lordship was dealing with proviso C, bundle page 127. He makes reference to Mr. Justice O'Farrell's judgment. In my judgment, BC has been unable to articulate any convincing reason why the parties considered objectively should have intended the result for which it contends. In other words, the result that handling the waste away from the facilities cannot be, the cost of that haulage cannot be deducted. Mr. Mort repeated his argument in relation to proviso B, namely that FCC's interpretation would allow it to deduct the costs incurred away from the facilities, whilst retaining the benefit of the cost of operating the facilities, which the parties envisaged it would be compensated under the guaranteed TPI provision of the PA. But I've already rejected that argument when addressing proviso B, and we say, yes, but the reason for rejecting 224 was that there wouldn't be any saving. Well, there would be, because they don't have the haulage cost plus uplift. And then finally, we say that this, our reading is much more consistent with the decision of Mrs. Justice O'Farrell. As we've already seen when looking at her judgment in Supplementary Bundle tab 15. She was dealing with the question of what was third-party waste income at paragraph 92. And she rejects the argument that the income needs to be generated after the waste has reached the facilities. And her reasoning is surely sound that the definition of third-party waste is it's defining the third-party waste by its end story. Where does it end up? That's third-party waste if it ends up at Greatmore. Income from such waste is third-party waste income. If the waste, paragraph 92, page 507, if the waste is in fact delivered to the facilities for treatment or disposal, then the income derived from such waste, whenever generated, third-party income. In other words, even if that income is derived before it became formally third-party waste as defined. And we say that the same approach should be adopted when looking at costs, the costs of handling or processing third-party waste. It's still such costs even though the waste has yet to reach the facilities. Well, I said I'd be half an hour. I just had 2 points left over from this morning I just wanted to touch upon. I think the main point I wanted to touch upon was just the suggestion that there were directly incurred costs in relation to the operation of Calvert or Hendon in the North London Waste Authority contract. Our fundamental concern is that's not the case that's been granted permission. The case that's been granted permission goes to the court's construction of the project agreement. It's inconceivable that the court would have given permission to appeal from a specialist court a decision about the assessment of the evidence or the application of or conclusions on factual evidence. Secondly, the court hasn't given such permission and we haven't come to court in a position to respond in detail as to what the position was. As I indicated before the short adjournment, the issue about manpower is primarily one to do more with case management and presentation and with evidence put before the court. And the judge's conclusions cannot possibly be faltered, particularly in circumstances where criticism was advanced after the draft judgment. There is no doubt that it seems highly likely, if not inevitable, that some of the costs of manpower were directly incurred, but they have never been identified. On the same topic, even if the court were to accept that some category of costs did satisfy the directly incurred requirement, as the judge hypothesised that there would be some, we still have the same problem with the information before the court. And in this context, I refer to the judgment at paragraph 249. So, core bundle tab 10, page 129, under the heading manpower. Paragraph 248, the quotes from Mr. Mackenzie's witness statement as to how you'd address manpower. And then at 249, the difficulty with that approach is that it's simply not possible to identify specific manpower costs which might individually fall within the definition of directly incurred costs. It is possible that some of them might, whereas in the absence of concrete evidence to the contrary, it is difficult to see how the cost of employing site supervisors and team leaders, for example, could ever be described as directly incurred costs. And that's the same, the Court of Appeal has precisely the same difficulty, however strenuously it's argued that some element of the cost should have been allowed to slip through. In terms of Calvert, I mean, again, we don't have a lot of evidence about the use of facilities because the appeal is supposed to be limited to point of contract interpretation and instructed that Calvert, the site that's used for the rail hall, is used for multiple purposes. Finally, my lord, the only other point I wanted to make was just suggested to me by those behind me. I hadn't made the point sufficiently clearly. If my lord has my lords have the extract from the core bundle which we handed up this morning, which was we had pages 254 to 256, which we put on a slightly larger font, the original version. The first page, as it happens, is North Hubs. And the very short point I just wanted to emphasise, if it hadn't been made clear, is when FCC applies overhead and say that they're making losses on this contract and so on, they, unlike the other items, if we look at the list of costs, most of them are done on this apportionment basis where they calculate a cost per tonne and then apply it times tonnage. But when we get to the divisional corporate operational allocation, they do what appears to be a percentage of turnover. First point, the court will note that that bears no relation to the percentage turnover that appeared in Gillian Sinclair's slides. It was 5.7%. So we've always been confused as to how they do this calculation. But secondly, the point I wanted to make now is that percentage is then just applied to turnover. There's no attempt to isolate what's the additional income over and above what we've guaranteed to which that percentage should be applied. Well, unless I can assist the court any further, those are my submissions.
Thank you.
Thank you.
Ms. Parkin.
My lords, I have four that I hope are going to be relatively short points for the court. The first point is that repeatedly throughout Mr. Mort's submissions over the course of yesterday afternoon and this morning, he referred to FCC as if it were one entity. This morning he said that BC regarded itself as joining forces with a huge waste disposal business and that it was entitled to receive, or that the group was receiving money twice in relation to haulage. As I tried to indicate and demonstrate in my submissions yesterday morning, this was a contract with an SPV who let subcontracts to various group companies, and in particular the court may recall I referred you to the Waste Finder Agreement, in relation to which the obligation to source, and I do emphasise the word source waste, was transferred to FCCR, and in return FCCR was required to pay the guaranteed third-party income to FCCB. As the court knows, waste can be sourced in any number of ways. The court is concerned with a period of time in which waste was sourced from other FCC group contracts. Now it is not. It comes directly from other waste company competitors. And the result of that is that BC does not benefit from any income that FCC generates from haulage. And just pausing there to pick up on another point which Mr. Moore made this morning, which is, well, FCC can hardly complain if it's entered into a loss-making contract. The point about the construction that we contend that this court should apply is not just it stops FCC making a loss. It's a much broader point than that, which is on our construction, everyone wins. And the council wins because if our construction is right, and we are entitled to deduct the costs that we incur in generating this extra income, then we will keep hauling waste from Hitchin to Greatmoor, etc., etc. The problem with the construction advanced by my learned friend is it is very much a construction which is killing the goose that laid the golden egg. And I took your lordships yesterday morning to Mr. Longden's witness statement in which he described how that was so. So that is point one. This is not a construction urged upon this court because it is a construction which benefits me. It is a construction which benefits both parties. Point two, something in relation to which during the course of this morning's evidence, submissions, the court might have been forgiven for thinking that I had misrepresented the position in relation to North London waste. I was very careful about what I said about North London waste, and that was based on the evidence. Some of that I took the court to in my first submissions, and that's at page 579 of the bundle. And that was Mr. Mackenzie's first witness statement.
Yep.
At paragraph 819 and 820. I'm going to hand your lordship up copies of Mr. Mackenzie's second witness statement, which was before the court. And if your lordships would be good enough to turn to internal page 10. You'll find a heading North London Waste Authority manpower costs exceptions. And under paragraphs 4.1 to 4.4, Mr. Mackenzie describes exactly how the North London transfer station costs were created. And he says at 4.3, I've since received clarification from my finance team that no actual staff costs were initially coded to the North London transfer station cost centre, as it was a virtual transfer station cost centre.
Where are you?
I'm so sorry, my lord. Page 10.
I see, yes.
4.3 at the bottom. Yep. Virtual transfer station cost centre, not an actual physical premises. The North London transfer station cost centre was set up to monitor the operation of bringing waste from North London Waste Authority to the rail siding at the landfill site and subsequent transfer of waste by vehicle from the siding to the Greatmoor facility. We wanted to measure the profitability or not of the activity on its own and not combine it into the landfill operation. To do that, we created a cost centre against which we posted revenues and costs so we could measure whether the activity was worth doing by creating this virtual transfer station cost centre. We're also able to accurately calculate the TPI relating to North London Waste Authority. The creation of the North London Transfer Station Cost Centre predates the need for the preparation of the additional TPI calculations. And just picking up very briefly on another point Mr. Moore made this morning, there was a suggestion that all of these costs were somehow recreated after the event. The costs simply come from the accounts which have been compiled for many years going back into, well, many years, but back for these purposes until 2016. They were not created after the event. They are the actual costs recorded in 2016. And then at 4.4, he goes on to explain how the individuals were drafted in from landfill site and the manpower costs relating to those individuals were coded to the relevant cost centre. And he says this is based on 7 full-time employees and the costs were taken directly from the payroll. This explains why the manpower costs relating to the North London transfer station includes reference to other departments and cost centres. So the costs that your lordships see in those spreadsheets, which your lordships have probably now spent way more time than you could have imagined looking at. Where they are in relation to North London, they relate only to the transfer of waste that goes up to Great Moor. Which is why I said what I said yesterday.
Can I just understand that? If we take what we were showing this morning, the blown up version of the pleading.
Yes, my lord.
That's page 255, is it?
Yes, my lord. Yes, that's correct. So if one sees the cost of manpower there,
And can we just, so I see the manpower element.
mm-hmm.
What about all the other elements?
all the other elements are costed in the same way as well. So this is what he means when he talks about creating a virtual transfer station cost centre for North London. And in terms of the operational overheads allocations here, what they are is the allocations by reference to the North London turnover, which one can see at the top there under the disposal Calvert Greatmore line item.
So, as regards items other than manpower,
Yes.
it has to be an apportionment.
Well, no, my lord, because as Mr. Mackenzie explained in his first, effectively, it comes to the train, it's taken off the train, it's put into trucks, and the trucks drive up to Greatmore. And so it isn't an apportionment because the trucks are only going in one direction.
Well, let's take, say, item 3, site costs.
Yes, my lord.
I don't know which site that is. Is that Calvert?
It is the Calvert. It is, yes, my
And
lord. Yes.
Calvert isn't just used to take things to Greatmore.
Of course, well, actually, Calvert is based within the facility, in relation to which there are there is a landfill site, and then there is Greatmore.
So some of what comes to Calvert goes to landfill, and that doesn't go to Greatmore.
In terms of the trains that come in from North London.
No, sorry. Can I just stick from
Yes, certainly, my lord.
The Calvert site doesn't just service the trains coming from North London going on to Greatmore.
Correct, my lord.
Therefore, if you've got an element for site costs, it's got to be an apportionment.
The reason that I'm pausing, my lord, is that depends on what sits underneath the site costs, as in precisely what is going into that site costs bit. So if it's my trucks analysis,
Well, that wouldn't be a site cost.
it would be a site cost. It's equipment, effectively, my lord, is what site costs is.
Well, why isn't it maintaining the buildings or insuring the buildings or I don't know what?
Well, because that's under fixed rents, rates and licensing.
Well, actually, there are no entries for fixed rent rates or licenses.
Absolutely, my lord.
So,
Because there are none which are referable to this, to the Calvert landfill site, in terms of the bit that goes up to Greatmore.
and then you talk about trucks. Well, isn't that haulage and contractors?
No, my lord. Haulage and contractors is the rail costs only, my lord.
So which we're talking about trucks going from Calvert to Greatmore.
Yes, my lord.
And where's the evidence about that?
It's what Mr. Mackenzie says in his witness statements at paragraphs 8.19.
Well, I thought rather when I looked at his witness statement, he seems to be saying we're apportioning. Just generally, he seemed to be saying we're apportioning.
I don't think that is.
I mean, if you take, say, 8.13.
8.13, my lord, is a more general statement.
And then he says 8.14, in order to calculate the costs which were included in the spreadsheets, we needed to carry out an apportionment exercise.
But, my lord, if your lordship reads down, he then talks about 8.17. Been told with 3 exceptions, BC is now accepted as a figures-on-figures basis, all of the figures. The 3 exceptions relate to, he talks about manpower costs there. So he's telling the court there how he has calculated manpower costs, and he says at 8.20 on the next page, the management accountant preparing the additional TPI calculations then sought out all the names of the people who worked at the transfer station moving the waste from the railhead to the EFW. She then sought out their payroll costs and over the relevant time periods. And then she was able to reconstruct the manpower costs which should have been recorded. which is what Mr. Mackenzie means when he talks about creating a virtual transfer station out of the North London costs. What the team has done is it has worked out what is related to the exercise of getting the North London waste to Great Moor.
Let me just find the spreadsheet again, which I've lost. I mean, maybe the answer is we really can't tell.
Well, we're going to take that a little bit further at the moment, because the court will see precisely what could or could not have been told. But that is effectively the evidence of Mr. Mackenzie, which is that these costs are the costs which relate to the Calvert train station, to the Great Moor facility. And that's why I said to you what I said when we talked about North London yesterday morning. The next point, my lord, concerns directly incurred. What does it mean? I understood my learned friend to say that directly incurred is synonymous with direct costs, and that's a term that's well used and recognised in the construction industry. It doesn't say direct costs, my lord. One may say that's always a cheap point, but it doesn't say direct costs. And indeed, if it were a term that were as well recognised as is suggested on the other side of the court, one might have expected it to say as much. It does not. As you know, my lord, we say that is not what it means. And the court, I sought to express my enunciation of the test to the court yesterday afternoon. Can I just take your lordships to the way in which my clients enunciated the test when they first provided their information to BC? And that's, I'm afraid, right at the end of the supplemental bundle at tab 47. And one sees there, I hope, my lords, supporting notes to TPI review.
Yep.
And if I could take the court, please, to page 932. This is a document prepared by Mr. Mackenzie. And he describes right at the top there, where he says this. The costs detailed are the costs of providing the services to the third party prior to the waste arriving at either Great Moor or High Heavens, the facilities. Without the operations that these costs cover, the waste would be unable to be delivered to the facilities. For clarity, these costs are not included in the base case financial model. And that, we say, is what directly incurred. An accountant expressing it much more eloquently than a lawyer perhaps ever could.
Yeah.
What then, let's assume for the current purposes that Mr. Mort is right. What does direct cost mean? Mr. Mort took you to an extract from his pleadings formulated in August 2022, in which he says, I conceded that manpower might or might not be, but we just don't know. We weren't given any information, he says, and that remained the position right up until the trial. That's not correct, my lord. And the reason it's not correct is to go back to the sampling protocol, which I referred the court to very first, I think fairly early on yesterday, but I perhaps made the mistake of not showing the court precisely what was involved. It's behind tab 1 of the supplemental bundle. And as the court knows, it was a sampling protocol which was annexed to an order of the High Court dated the 27th of April 2023. We're going to start with paragraph 6, which is on page 10 of the bundle. The purpose of the protocol is to provide for the proportionate and reasonable disclosure of documents relevant to the values asserted by FCCB in the third-party income review. So from paragraph 6, we know that what this protocol is concerned with is documentary evidence. Paragraph 10, right at the bottom of page 10, it is anticipated that FCCB will provide written explanations and or narratives to accompany documents disclosed in order to avoid or minimise problems. In addition, the parties agreed that it would be helpful to have meetings, either on an open basis or a without prejudice basis, depending on the nature and the purpose of the meeting, in which FCCB walked BC through its calculations. And then what the parties do at paragraph 12 is they describe the procedure that was to apply. And they do it first of all in relation to the Hertfordshire series of contracts. And then they say the same process is going to roll through. So the first thing they're going to do at 12.1 is provide a spreadsheet containing the calculations, which includes additional workings showing how the values are derived from the underlying profit and loss accounts for that contract. It also records that we'd provided a transaction listing. And then at subparagraph 3, it provides that the parties will attend a meeting so that FCCB can explain how the transactions from the transaction listing feed into the P&L and ultimately into the TPI calculations. And then at 4, BC was to select a proportionate sample of the transactions. And then FCCB were to provide supporting documents, including invoices for each of the transactions in the sample, or to allow BC to view FCC systems at its sole discretion. 5, if BC has any reasonable follow-up questions on either the P&L sheets, listings following the meetings, or the supporting provision of the supporting documents, then it's going to ask them, and FCCB will respond. Now, that process took place over a 6-month period. And, my lord, BC, not surprisingly, did have some questions. And what we've done behind the other bit of those that file we've just handed up, my lord, is we have included an extract from the questions that BC had. It's in the trial bundle, and it's also referred to in that witness statement of Mr. Mackenzie that I've handed up to the court. And it's at the document reference is L1599. That was the reference in the electronic trial bundle. And what we've done is there were lots and lots of questions. This is in relation to Hertfordshire, so it's the first set of contracts identified. And question number 32, so there were lots and lots of questions which went before that and come after this, but I'm just doing manpower for the sake of argument. We were asked by Buckinghamshire, please provide a full establishment breakdown by job title grades for manpower costs allocated to each transfer station and explain the allocation methodology. Please provide a job description for each grade of staff which describes the work which staff are undertaking for the North Herts contract. And the answer one can see in blue, see separate worksheets, and for a full breakdown of manpower by job title and grades. And then it says, see worksheet Herts role definitions for a zip file containing the job descriptions for each role. And then if one turns over the page, I'm afraid that these are very, very small spreadsheets. But in the middle of the first page, and this is an extract for the people who are working at the Waterdale transfer station, one can see an item in the middle of the page, There's in the green boxes, there's a reference to job title.
Yes.
Charge hand, contract supervisor, site operative, loading shovel driver, etc., etc., etc. Down it goes. And then at the next page is an extract provided from the Hitchin transfer station. Plant operator, site operator, relief plant operator, etc., etc. Down it goes. Now, what I haven't printed out for your lordships, given the volume, is the zip file containing the definitions of all the things that these people were doing. But there were definitions of things like what a charge hand does, what a HGV Class 1 driver does, what an LGV driver does, what a shovel operator does, what a site operator, relief plant operator does, what a weighbridge operator does. That happened for every one of these contracts. The idea that my learned friends' clients did not know what these people were doing on site is simply wrong. Now, this was the evidence that we put before the judge, and he held it wasn't enough. And the reason that he held it wasn't enough is because of the test he applied to directly incurred. And you may remember, my Lord Justice Newey and I had a discussion for which I was roundly criticised for my juniors by not saying with respect to your lordship yesterday, for which I apologise, and I'm going to say it now.
I normally think that saying with respect makes it worse.
Well, I shall tell my juniors that. I referred your lordship to paragraph 208 of the judgment, where I said that what the judge had done was he'd said that we needed to identify someone additional to do this work. And you can see how that is carried through if you look at his judgment at page 129, core bundle tab 10, and I'm looking at paragraph 251. So 251, he starts by saying, this is not so much a point about apportionment as about the distinction between direct and indirect costs. Now, just pausing there, the reason why he says it's not so much a point about apportionment is that when he comes to look at the Luton issue, he recognises that if he is going to apportion Luton income, he's going to have to do the same with Luton costs. And one sees that from paragraph 311 of his judgment at page 139. So he's not rejecting these costs on an apportionment basis. He says it's about the distinction between direct and indirect. He says, then he goes down to say, 4 or 5 lines up from the bottom, as to the latter, this is more a point about identifying, if possible, which, if any, manpower costs can be said to be directly incurred in generating the income from those which cannot. As I've already said, I can well appreciate that it would probably be difficult, if not impossible, to identify individual employees who worked on waste destined for Greatmore and nothing else. Pausing there, yes, absolutely. Equally, however, I can see how it might be possible to identify and separate out the non-operationals from the operational staff. Pausing there, please see the spreadsheets that I've just taken the court to. And then this, or the core staff required regardless of workload from those whose number is dependent on workload, and to make a case based on evidence that the latter category of costs might, and I emphasise might, be capable of inclusion as direct cost, and then as apportioned to Greatmore based on the volumes of waste sent to Greatmore from that facility, as opposed to the other waste treatment destinations. So what the judge, in my respectful submission, with respect to the judge, is suggesting is that we have to identify a person who is there because of the need to deal with the Great Moor waste. We then have to identify some evidence which shows that that person is capable of being included as a direct cost. And we then apportion that cost based on the volume of waste sent to Great Moor. And in my submission, my Lord, if one has regard to the waste industry in which both of these parties operated, one is forced to conclude that that is a test that could simply never be met. And that the only way of doing it, as the judge appears to recognise when he talks about Luton, is that if an apportionment of income is being allocated to these third-party income calculations, then you have to approach cost in the same sort of way. Primarily for the reason that Mr. Mackenzie identified way back in December 2021. Without incurring these costs, the waste could not arrive at Great Moor.
Can I just pick up on it? You touched on this earlier in your submissions yesterday. You say there, if a proportion of income is being allocated, in what sense is a proportion of income being allocated?
It's being allocated, my Lord, sorry, excuse me, in relation to the Hertfordshire contract. We are being required to give credit for the income we receive in operating the Hertfordshire waste transfer stations at Hitchin and Stevenage and Waterdale. And I showed you where those were on that map yesterday. What we have done is say, we get paid, I'm just going to take a figure out the air. Let's say I get paid £100,000 for operating a transfer station, and 50% of the waste leaves that transfer station to go to Great Moor. In these third-party income calculations, we have included 50% of that £100,000. And we are simply seeking to deduct 50% of the costs incurred. And you might remember, my Lord, yesterday afternoon I identified three rather stark propositions to the court. I said there are three ways of doing this. Either none of the costs are deductible, all of the costs are deductible on the basis that actually I have to incur the full costs of operating a Waterdale transfer station in order to send 50% of the waste to Great Moor, or a portion of the costs are deductible. My learned friend urges on you the none of the costs are deductible and we just take the income. And I urge upon this court the 50% of the costs are deductible because you've had 50% of the income. And just turning around and coming back and thinking about the purpose of this TPI clause. What's it trying to do as a whole? It's trying to allocate a profit share. And that was recognised yesterday when Mr. Mort talks about the immense profits that are apparently being generated by the FCC group. So it's trying to make an allocation of a profit share and also to incentivise the contractor to maximise that profit share for the benefit of both parties. And that is ultimately the purpose of what this clause is trying to achieve, and how we say the court should have regard to that purpose in the construction exercise that it's got to undertake. And unless I can assist the court any further.
No, thank you very much, Ms. Parkin. Mr. Mort, do you wish to reply on your appeal?
I don't think my learned friend has said anything about...
No, in which case I suppose it follows you can't reply on your
I
appeal.
can't legitimately reply.
No, that's a fair point. So much the better. You will be staggered to know that we're not going to give judgment here and now. You will be supplied with the judgments in draft in the normal way. We'd be grateful if at that stage you would seek to identify our typing and English errors, not of course to seek to re-argue the case. We'd also be grateful if at that stage you would seek to agree an order dealing with consequential matters. If there are points on which you can't agree, could we please have brief written submissions, and we would expect to deal with the points in the order that we make. Finally, I ought just to remind you of the importance attached to the embargo. I think you've already supplied lists of names to whom the draft should go. If you think of anybody else who should see the draft, then obviously you need to come back to us rather than simply supplying it to them without the court's permission. But thank those of you with speaking roles very much for very clear submissions, and thank everybody else too for their contributions.
Whoever